Hello everyone, welcome in. In this video, we will be discussing a response to the initial complaint in the civil case against Artesia General Hospital made by the representative of Team Trevizo, for lack of a better term. One quick note before we get started, the representative Arthur Bustos that you will see still listed on this response has actually passed away. He passed away in mid-September, late September 20th. And so that doesn't really mean anything for the case other than a new representative will be put in, but it just also means things may be taking even longer unless that happens, while all the other things that we will learn about from this response will happen. So here is the first response. It's basically a motion to stop the proceedings. I'll go through this and highlight the important parts, and then I will explain the New Medical Mexico board thing. That's basically, it's kind of like arbitration for those of you who know what arbitration is, and we will get through basically what that will look like. So it comes now defendant Heather Marshall through her attorneys, and she is basically saying that this complaint was filed, and this is a response to the filing, which you'll see is important later. At all times, Heather Marshall Vaskas, or Vaskas, I'm not sure how she pronounces it, my apologies, was a qualified healthcare provider. The MMA precludes a plaintiff from pursuing a claim of medical negligence against a qualified healthcare provider in court unless the New Mexico Medical Review Commission, NMMRC, has held a hearing and issued a decision regarding this claim. Plaintiff has expressed its intent to follow the process mandated by MMA and will submit an application to the NMMRC against Dr. Vaskas. The NMMRC has not yet held a panel hearing regarding Dr. Vaskas and is required by the Act prior to the filing of the complaint. Plaintiff is required to obtain a decision on his claims before the NMMRC prior to pursuing his claims against Dr. Vaskas in court. As a result, defendant requests that the court stay proceedings pending a determination by the NMMRC. Dr. Vaskas will answer plaintiff's complaint within 30 days after the panel's determination. Defense counsel has reached out to plaintiff's counsel and no opposition was given. Wherefore, the foregoing means Heather Marshall Vaskas, MD, requests that the court stay proceedings pending a decision by the NMMRC and for other such relief as the court deems proper. So, the reason why we're seeing this and not a motion to dismiss or summary judgment or just moving forward with the case is because here is the MMA, what they kept referring to by MMA, the Medical Malpractice Act. And if you would like to pause and read here, it's basically just saying that you have to go through this, for lack of a better term, arbitration medical board before you can bring these kind of claims in court. And then down here, DNMLR Civ 7.1 is what they referenced, basically saying that you are responding to a motion. It's a legal formality, so it's not necessarily a law regarding any of the proceedings, right? So, but I figured I'd still throw that in just in case anyone was curious what that was. So, this is where we get into the heart of it. This is the actual procedure for the hearing complaint. This is from the New Mexico Medical Society, which is basically composed of doctors and lawyers and what have you, that will oversee all of these issues. This is good and bad in certain ways. It's good in the way that they could, well, let me preface it with this. No matter what they say, you're still allowed to bring your claims in court no matter what. You're still allowed to defend yourself in court no matter what. These people just are trying to help you come to a resolution without burdening the court, as well as wanting to know, obviously, what's going on in the medical community, so they need to be informed whenever these things are happening as this type of governance board, right? So, the things I don't like about this is as we'll get into it, I believe it's point 7 here. You can see attorneys for the parties involved will not be permitted to accompany them in the informal hearing for the committee, I do not think that's very fair. I don't enjoy anytime someone is disarmed, for lack of a better term, without their attorney present when they're in this kind of form of arbitration, because it doesn't matter who you are. There's a reason for wanting your attorney present in this. Now, they will be present for the formal hearing, but again, I just would prefer attorneys to be allowed all the time. So let's go through the procedure for the hearing and complaints. All complaints must be submitted in writing to the committee at the office of the New Mexico Medical Society. The individual against whom the complaint is filed will receive a copy of the complaint and be given a reasonable time period to respond. A copy of the committee procedures for the hearing complaints will be forwarded to both parties. The committee may strongly urge that both parties involved make a sincere effort to resolve the dispute without the necessity of appearing before the committee and to notify the committee of the results. Again, this is one that I kind of don't enjoy because this is, in my personal opinion, this needs to be smacked down in court. And that's just how I see it. But this is like asking them to resolve it. And in this particular case, it's kind of a moot point because I feel like the person representing baby Alex in their side obviously wants to go forward because wrongful death is a huge payout for them. And the hospital, Dr. Vaskas, and any and all defendants included in this suit are gonna want to defend themselves. So this is kind of annoying to me personally. It's a process that I think is kind of wasting time because they aren't legally binding. The only way they're binding is that you have to go through them first. Whatever they say isn't going to be upheld. So it's just kind of annoying to me, kind of a waste of time and a work around the system because only a select few of issues regarding medical malpractice and stuff are very open and shut. But yeah, it is just a little bit annoying to me. I feel like select cases are ones where everyone can settle and just agree to whatever terms. But when it comes to specifically medical issues, they get so deep and lost in the weeds. And, sometimes I feel like this is not a great use of anyone's time or efforts. But anyways, let's continue. Enough of my ranting. If efforts have been unsuccessful, because like I said, there probably are going to be, if efforts have been unsuccessful, the committee will hold an informal hearing. The chairman will select 5 members of the 10-member committee to hear each case, with not more than 3 members from either profession. 3 members will constitute a quorum for the hearing, and not more than 2 members from either profession. It is expected that the chairman of the committee will perform the necessary investigation pursuant to consideration of the case before the committee. Either or both parties may attend the committee hearing at which the complaint will be considered. Attorneys for the parties involved will not be permitted to accompany them in this informal hearing of the committee. See paragraph 14 and we'll get there. Deliberations of the committee will be held in executive session with a vote being taken by a written ballot. Decisions of the committee will be reported in writing to both parties involved. Minutes and records will be retained. Proceedings of the committee will be confidential. However, flagrant or repetitive complaints may be submitted to the disciplinary committee of the respective organization by a majority vote of the committee. If either or both of the parties do not accept the opinion of the committee, then the committee may offer a binding arbitration agreement to both parties. So again, another thing that I don't like, this is just them trying to get them to settle out of court and not take it any further. But when I get into what my opinion is on this, if I was them, meaning the hospital or Dr. Vaskas, I would take this to court. I would not settle. We'll get into that in a few, but this is why this annoys me a little bit. It's like, binding arbitration agreement for what? The hospital, in my opinion, didn't do anything, and legally they're cleared, in my opinion. So I think that, this is annoying. Should both parties sign a binding arbitration agreement, the chairman of the committee will appoint 3 members from the 5 members of the committee who are not selected to consider the complaint at the informal hearing. The chairman will select no more than 2 members from each profession to hear the case under the arbitration agreement. Attorneys for the private parties involved may be present at this formal hearing. There we go. That sounded more like it. Either or both parties may employ a court reporter for the evidentiary hearing at their own expense. However, the committee must be supplied at no expense to the committee a copy of any transcription made of a court reporter's verbatim reports. Under arbitration agreement, all records are to be maintained. Deliberations of the arbitration committee will be in executive session. Only complaints of interprofessional relations will be considered by the committee. So from here, I kind of already put my rants out as to why I feel like this is an unnecessary situation for arbitration with this case. The one positive thing that might happen is obviously when the committee makes their decision and is trying to push this forward, they could see right through everything and say, yeah, there was no malpractice, there was no negligence. Like in my video when we went through the complaint against the hospital for wrongful death and all the other claims, we were very aware that they fudged the truth a little bit and they blurred the line of the facts surrounding the case. And so when the facts get presented, I think things are going to be a whole lot different. So from here, this is getting a little bit more into my opinion, but this is where I think it should go and where it probably will go, is after this whole arbitration thing happens, I just don't really see Team Trevizo giving up, because again, like I said, until a court tells them they're not going to be able to get the money from the wrongful death suit and to be able to bring these claims, I don't think they're going to stop. I don't think they'll sign an arbitration agreement. I think they will assert their right to go to court. So that's just my opinion, but it seems like, why would they give up? Especially if in the arbitration all the facts come out and they say, well, you're not really entitled to anything, right? So they're going to want to take it to court. When that happens, depending on what the attorneys for Dr. Vaskas and the hospital and the other defendants, who, if they get personally involved in this as well, will want to do, in my opinion, is not ask for the case to be dismissed. As you see down here at the bottom, I have a little thing explaining the difference between a case getting dismissed is an issue of the claims not being right, or it's usually an issue with the claims, right? They're not the right claims. You have to bring a different claim, stuff like that. Motion for summary judgment is an issue of the facts, and that's where I think we're at with this civil lawsuit, because the facts are, especially on the wrongful death claim, that Alexee did that. There is nothing indicating on the autopsy that the medication given was anywhere near a dose that could have hurt baby Alex, meaning the morphine. We actually have facts that the phentermine that Alexee willingly took herself is, I believe it was 200 times more present in the baby's system. It was a whole lot more present in the baby's system. So when you get down to it, if I was the attorneys, or if we were working on the case, I would say wait for a little bit of discovery, get all the information that you want, and then issue a motion for summary judgment. And you may not even have to really do discovery if you don't want to, seeing as there's so much already out in the open thanks to the criminal investigation. So now you get to bring up the criminal investigation when you're saying, hey judge, and maybe I should explain to you. Motion for summary judgment, for those who don't know, is when you're basically asking the judge to decide on their own right now. We're not going to trial, we're not doing that. I'm asking for a motion for summary judgment, and because the facts in this case are so what's the better term? Because the facts in this case are so in favor of one side, but no matter what side it is, it's just such an obvious decision, right? Motion for summary judgment is basically exactly how it sounds. You motion for the judge to end it right then, not for it to be dismissed, because case dismissed is an issue of the claim. Let's say it was a civil lawsuit against a doctor and they were trying to sue the doctor for battery, but it was actually medical malpractice. Then you would ask for the case to be dismissed, and then they could bring it under the correct claims. But in this case, they've brought the right claims, right? They brought the wrongful death because there was a dead baby. They brought the medical negligence and malpractice, all that, all the claims that we went through in the wrongful death complaint video. They brought all the right claims, but their facts aren't there. They don't have the facts to back it up. So that's why I'm saying eventually, if I was their attorney, as soon as the arbitration's done, let them do their initial, Heather Vaskas will respond within 30 days. My initial response would literally be a motion for summary judgment. And I would attach the autopsy for the baby, the toxicology reports, all the witness statements, all the footage, all the police body cam footage, and basically shows Alexee admitting to all of these things. And then I would ask the judge to make a personal, decision on if the hospital, because really the biggest question is, should they have told her sooner? Was the doctor too slow at telling Alexee she was pregnant? It's the only issue at hand here in that case. And again, that's not I guess you could ask for a dismiss on that claim, but overall, since they have so many other issues, you want to go for motion of summary judgment and just be like, this is all, for lack of a better term, bullcrap, right? Not to be crass, because it is about overall, the wrongful death is about the death of poor baby Alex. But in my opinion, the hospital is not, will not, cannot, shall not ever be the cause of death for the baby. It just doesn't make sense. Also, it's quite infuriating that it just doesn't make sense. They never put the baby in the bag. Only one person put the baby in the bag, and that's what the autopsy says killed the baby. And this isn't criminal court where the burden of proof for the autopsy is so high. Basically, the burden of proof for if you were to file a motion for summary judgment and attach that autopsy, the judge just needs to believe 51% that the autopsy is correct. So the judge is very likely, in my opinion, to rule in favor of the defendants in this case. I really don't see another way around it. This is not your typical medical negligence case. There's not a lot of issues being brought up that can actually be questioned, like in the Take Care of Maya, the Kowalski case. There are issues where you can ask, like, what was that in the best interest of your patient? Were you taking care of your patient? Were you doing things right for Maya, right? I know some of you are following that, and I know some of you aren't, but that is all about medical issues and how they treated their patient. And I think we can look at the stark differences in the patient, right? Not in the hospital. I say we compared the patients in this case. In Take Care of Maya case, you have a 10-year-old girl presenting with some pretty severe issues. Seemingly, the 10-year-old is being honest. I know they had questions about the mother, but the patient themselves was honest and was innocent, right? She was a young child, 10 years old. In this case, Alexee was a 19-year-old woman who was pregnant and, by all accounts, kept denying that she was pregnant. So you got to kind of look at the issue here and say, well, shouldn't Alexee or baby Alex get his day in court? Yeah, he is, through the criminal case, not through this civil case, because the one way, in my opinion, that justice would have been brought civilly against Alexee would have been if Devin had brought a wrongful death suit against Alexee for the baby. I see that making it to trial, making its way through court. I do not see this one making its way through court. I will be shocked if it does. On the screen here, sorry, I've been talking for quite a while, but on the screen you'll see here, this is the rules for summary judgment. There's a little bit more, but this was what really is what's pertinent to this case, the time and procedure. And it just says a couple interesting things here when I'm talking about it. It's an issue of fact, right? Not an issue of the claim, because they're making the correct claims. They just don't have the facts to back them up. For a defending party, B, a party against whom a claim, counterclaim, or cross-claim is asserted, or a declaratory judgment is sought, may move with or without supporting affidavits for a summary judgment as to all or any part thereof. Motion, the judgment sought shall be rendered forthwith if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there are no genuine issues as to any material fact, and that the moving party is entitled to a judgment as a matter of law. A summary judgment, interlocutory in character, may be rendered on the issue of liability alone, although there is a genuine issue as to the amount of damages. If alternative grounds for summary judgment have been presented to the court, the order granting or denying the motion for summary judgment shall specify the grounds upon which the order is based. D. Time and procedure. Motions for summary judgment will not be considered unless filed within a reasonable time prior to the date of trial to allow sufficient time for the opposing party to file a response and affidavits, depositions, or other documentary evidence, and to permit the court reasonable time to dispose of the motion. The moving party shall submit to the court written memorandum containing a short, concise statement of the reasons in support of the motion with a list of authorities relied upon. The party opposing the motion shall, within 15 days after service of the motion, submit to the court a written memorandum containing a short, concise statement of the reasons in opposition to the motion with authorities. The moving party may, within 15 days after the service of such memorandum, submit a written reply memorandum. Passed to, on the bottom, but on this other second one, a memorandum in opposition to the motion shall contain a concise statement of the material facts as to which the party contends a genuine issue does not exist. Each fact in dispute shall be numbered, shall refer with the particularity to those portions of the record upon which the opposing party relies, and shall state the number of the moving party's fact that is disputed. All material facts set forth in the statement of the moving party shall be deemed admitted unless specifically controverted. Supporting and opposing affidavits shall be made on personal knowledge, shall set forth facts as would be admissible in evidence, and shall allow affirmatively that the affiant is competent to testify to the matter stated therein. So, a lot of legalese in this, but essentially what this is saying is, to put it in plain English and a satisfying way, basically, once they are ready, the attorneys for Heather Vaskas, the hospital, and all the other defendants that will be named throughout this case can basically say, here are our sworn statements and affidavits that this girl lied to us, told us she wasn't pregnant, deceived us this whole time. We tried our best. She continued to lie to us. She put us in a horrible position. Now we all have post-traumatic stress. We're all upset. She has caused issues throughout the hospital, however else you want to put it. And here's the autopsy stating that she killed the baby. Here's the here's the toxicology stating that we did not hurt the baby with our morphine. Yada, yada, yada. Motion for summary judgment. They have no facts. We have all the facts. And all those affidavits, all those facts are taken as evidence in this motion for summary judgment. And boom, it would be over. I can't say that'll happen exactly, but my money's on that because I'm almost certain that it would be their duty as the attorneys for Heather Vaskas as well as the hospital to move for a motion for summary judgment after all this arbitration crap goes through. I don't mean to be a hater. If you're a fan of arbitration, if you're an arbiter, I am sorry. I'm not a hater on arbitration. I just sometimes think it's a waste of time. Not all the time. Sometimes people settle and it doesn't waste the court's time. There are times where it works. But in this case, unless one of them is willing to back down, it's not going to work. And I'm only hopeful that one side backs down because I do not want the hospital or the doctor or anyone to settle with Alexee on this when they really didn't do anything wrong. We went through the complaint. The biggest issue they have is that the doctor didn't tell Alexee in a timely manner that she was pregnant. That's their biggest issue. That is not a legal issue. That is not a, it goes back to talking about how that's an issue of claim. Yeah, they don't have the facts to back the claims that they've been saying. But their only solid claim that might have any fact is that the doctor took 48 minutes or something like that to tell Alexee she was pregnant, and she's still never really been told Alexee she was pregnant because Alexee took that chance away when she gave birth, and so she wasn't pregnant anymore. Then the doctor thought she had a miscarriage, and then when she told Alexee that, Alexee denied that she could be pregnant in front of the RN, which I talked about in my video. Sorry about the audio on that video. It was really bad, but anyway, sorry that it was really bad. But the RN states that is when Alexee still denied her pregnancy, and that's not hearsay. That was, she was there for that conversation. So, all of that being put into a motion for summary judgment is almost certainly going to have this case be over before it even starts. And I think a motion for summary judgment is much more impactful than the case being dismissed, because cases get dismissed all the time and are able to be rebrought. Motion for summary judgment means you're done. You are done. It's over. You can't You can't try again. You were wrong. You tried. You have no facts, right? Because again, at the end of the day, it's all about truth and facts. And so if you don't have the facts, then you're done. If there was even a whiff of facts, then and that, the hospital was at fault for anything, then maybe. But again, not on just the wrongful death claim, because, that should be thrown out without any issue. All of the negligence or medical malpractices, all the medical malpractice claims and all that really don't result in any damages, because Alexee, she wasn't maimed, she wasn't injured, she wasn't scarred. What damages has she resulted from the hospital? Nothing. So again, I really am hoping for a motion for summary judgment. If we could look into the crystal ball and see the future, I would love that. But it can only be my lowly paralegal prediction over here that that's most likely what's to come after this whole arbitration crap. And sorry again to call it arbitration crap, but, making them sit through an informal meeting without representation and then making them come through a formal meeting with representation, doesn't that just sound like a whole bunch of hullabaloo? Why don't they just get the facts, make a decision, and say this was our decision, now go to court? I just personally don't really see this getting anywhere in arbitration, because what are the Trevizos just going to drop it and back down? Because the facts really aren't on their side, unless this medical board really does think that the doctor messed up and shouldn't have authorized the morphine and took too long and all that. Again, Alexee doesn't have any damages that she suffered, so if this is internal medical issues going on with this board, I get it. But once this gets to court, this has motion for summary judgment written all over it, unless by, some miracle the Trevizos are told you're going to lose in court and you're wasting your money, or if they are having to pay for it, I don't know. Maybe they would decide to drop it. But I highly doubt that. That's just my opinion. I don't know why you'd start a wrongful death, and other than for supplementing the criminal case, which they'd still want. So of course they would want to go forward with it, right? So if they're trying to get supplemental information out of the hospital to help them in the criminal case against Alexee that they don't have to share with the state, then that is always a positive for Gary's team. But when it comes to the case having legs on its own, the civil case, it's just not there. I just don't really see it. For this arbitration, hopefully the doctor and or hospital or other defendants are not scared into backing down against this. I really don't think that they rose to the level of negligence, malpractice, anything like that. They really didn't. I don't think waiting too long to tell someone that they were pregnant before they ran themselves into a bathroom and gave birth to a child allegedly, and then allegedly put that baby in a trash can and closed that bag up and put a new trash bag over that allegedly. I don't think that the doctor or the hospital is responsible for darn near anything they did that night, because these circumstances were out of their control and they were dealing with someone who was acting abnormal, not in the sense of abnormal that they should be able to deal with. This was abnormal in the sense of, and they can say this in their case if they want, since Alexee's being charged, potential criminal activity. No wonder they were being thwarted, right? And so I do think that there is a really high chance that the attorneys can just smash this down in court for the hospital, the doctor, and everyone else. But we'll have to see as that comes around. Sorry if this was a bit chaotic, but there is a lot of different levels in regards to, like the motion for summary judgment and this weird arbitration thing. Again, if you're an arbiter or you're a fan of arbitration, I don't hate it in all senses, and I'm not a big hater of it all the time, but I just think in this case, it's a waste of everyone's time and efforts. Let's let the attorneys do their thing and squash this how it is. But I also understand the New Mexico Medical Malpractice Act, in that this is codified in their law. It has been for a very, very long time. So it is what has to happen. Just annoying, just a waste of time. Because essentially, if I was the attorney on this case, I'd be rearing to write this motion for summary judgment. The only one positive is maybe it'll gear you up for your arguments, and you get a little taste of the other side, because I know, in my opinion, no one's dropping this thing and no one's settling. So let's just get ready for court and size up our opponents through this arbitration process, I guess. That's how I look at it, because according to law, they have to do it. In the end, the only thing that matters is getting justice for baby Alex. Alexee walked around fine, went to prom, nothing bad happened to her. So since there's no damages, I really don't think the hospital's on the hook for anything. And since the burden of proof is lower for the evidence that's going into a civil case, it's very likely that the judge will look at the autopsy, toxicology, and rule in favor of the defense and say, yeah, motion for summary judgment granted. There are no facts to support these claims. So that is my summary of this here motion to stay the proceedings. If you've made it this far in this video, thank you so much. If you are interested in following these cases to trial, please follow, as I will be covering them all along the way with a legal focus. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible, as I do really enjoy the conversation. It's your girl Friday. I'll see you in the next video. Okay, bye.